The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show. Tonight we're talking about when children are injured. You can call 844-7000-LAW to leave us a voicemail with your question, or you can email us at questions@siniardlaw.com. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley. They're focused on giving back to the community through legal education like this show. Siniard Law is accredited by the Better Business Bureau and has been recognized 4 years consecutively by best law firms in America. And they've got almost 300 five-star Google reviews. Now to our topic of the night, personal injury claims for children. Bart Siniard and Barnes Hayward are here, attorneys from Siniard Law, to give you details and answer your legal question. Boy, this is a tough topic. Nobody wants to hear about children being injured, but it happens.
It does. And there's a lot of legal differences when the person who's hurt is a minor. And that's what we're going to jump into. It's tougher emotionally. Most parents would rather just take the injury themselves than have their kid hurt. But it's not how it works. And all we can do is try to get compensation for the child. And how that works is a little bit different. And there's some things that maybe don't make common sense. And while we're here, Barnes, let's just talk about that.
Yeah.
What does the settlement process look like when it's a kid's personal injury claim?
Yeah. Because children, they're not at the age of consent, because especially for young children, they can't negotiate on their own behalf. Mm-hmm. We have to have safeguards in place to protect them because of how vulnerable they are. And the primary safeguard that we have is that for almost all personal injury cases involving minor children, the court has to approve the settlement. The court has to approve it to make sure that it's in the best interest of the minor child, to make sure that it accounts for not just past medical treatment, but future needs, future medical treatment. If there are disabilities that the child might suffer for and that need to be accommodated. And so the judge is there to referee and to make sure that the child, that their interests are being looked out for. So it's a formality, and it's one that we have to do, like I said, in almost every single case. But I don't think I've ever been a part of a pro-ami proceeding where a judge has denied a settlement or not approved a settlement that we've made on the client's behalf.
Yeah. I have seen some that a judge did not approve of. Not any cases that our firms handled, but that can happen if the judge thinks it's an insufficient settlement or that the attorney's fee or their expenses are too high. So that can happen. And like Barnes was saying, it's to protect the child. And most parents are good. Most attorneys are good, but there's some bad apples out there. And for that reason, a parent can't just settle their kid's case and get a bunch of money, because it's not always used for the child's benefit. Mm-hmm. And it's the child's money, not the parent's money. So we have these safeguards. And in addition to having that hearing, usually a judge appoints what's called a guardian ad litem, which is an independent lawyer who usually meets with the family, reviews all the evidence in the case, and gives a formal recommendation to the judge. Yes, I think this is in the best interest of the child, or not. So yeah, we got to have some safeguards because it's important that we protect, kids' money from sometimes parents who want to use it for their own, trip to Hawaii, or sometimes the lawyer didn't really do a good job and the judge was like, no, go do better. So that's why we have it.
Yeah, hard to imagine. So a guardian ad litem, that's a good vocabulary word.
Yeah.
If you have any legal questions on this or any topic, just email us at questions@siniardlaw.com, or you can call 844-7000-LAW and your question may be featured on the Siniard Law Show. Now to our legal tip of the week. Who gets the money in a personal injury settlement for a minor? Y'all touched on this a little bit.
Yeah, we talked about the actual process of it, but I guess we didn't really talk about where does the money go. And there's a few different options. Some are more common than others. Do you want to answer that?
Yeah, I mean, the most common option, and so to start, at least in Alabama, you don't reach the age of majority until the age of 19. So whatever money we recover on a minor's behalf, they don't typically, and there are exceptions that a judge can make exceptions in any case, but typically they don't have access to that money until they reach the age of majority. So the most common thing that happens is that money gets held in a trust account with the court. It's an interest-bearing account, and it's held there until they reach the age of 19, and then they can have access to it. But it's a low interest-bearing account, and especially where we've got someone with really severe injuries or where we've recovered a more significant sum of money, we're going to be asking the family to look at structuring that money and placing it into an annuity where it can grow while the child is getting older. And then typically that money is paid out over a period of payments. And there are lots of different ways to structure it, but it makes the money go much, much further than if you just took that lump sum and stuck it in that interest-bearing account with the court.
The great thing about a structured annuity is, well, if you do it the other way, where the clerk's accounting office just holds on to it, your kid, once he or she turns 19, can just go get it all. Most people at age 19 aren't that responsible with money. I know I wasn't. So when you've got a child who's injured and say they're 10 years old, the parents have some control when they're using a structured annuity. We can say, we want, our son to get 30% of this when he's 19, but the other 70% we want paid out when he's 25 years old. And that kind of locks the money up and can prevent a 19-year-old from making poor financial decisions with a large amount of cash. The other good thing about a structured annuity is the interest that compounds is tax-free. Like all personal injury settlement money is tax-free. But if you take it, if I got a personal injury settlement and put it in a CD, the interest it gains is taxable. But in a structured annuity, for a minor, that interest that's gained is also not taxable. And so if you've got, a 6-year-old and it's going to be maturing at, 14, 15, 16, 17 years, the amount of interest that compounds is going to be big, and you want that all to be non-taxable.
And do you have latitude into where that's invested?
You have a little bit. We generally, what we do is we recommend a broker that we have familiarity with, and they kind of shop around to get you, different deals to look at from Fidelity or the Prudential or Edward Jones, respected companies. You want to make sure these are legitimate companies that aren't on the verge of bankruptcy. So we help our clients out with that process. And then you can kind of customize the plan. What is the payout? What percentage at what age? Things like that. Because everybody wants something a little bit different,
Yeah,
sure.
And by the way, we, the attorneys, the law firm, that we don't benefit in any way from recommending these structured annuities. There's no kickback to us, and there's no added fee for us to help you set it up. It's just something that we offer as a courtesy because in most cases, it's going to be in the child's best interest.
Right.
Yeah.
And this probably goes without saying, but if they needed it right then because they have medical problems, then...
No. So that brings us to the third option. And I've only actually done this once in my career. So to recap, first option, you put it in an interest-bearing account at the courthouse. It grows a very small amount of interest. You can go get it all when you turn 19. Second is the structured annuity option, which we've just talked about. The third, which is unusual, but I've had to use it once, where I had a very young child who had very significant medical conditions. Some of them were related to the incident, some of them weren't. She was born with them at birth. But it was a very large settlement, multi-million-dollar type settlement, and we put a good chunk of it into a conservatorship. And a conservatorship is basically a legal thing where it's for the benefit of somebody who's incompetent or a child when they come into a lot of money. And a conservator is appointed, and it can usually be a parent that can access the money to use it for the child's benefit, but has to report to the judge usually 2 times a year, depending on which court system you're in. You have to like do an accounting. Say, I spent this on this, this on this. And so the judge is reviewing this to make sure you're actually using the funds for the right thing. And if you're not, you can get in big time trouble, fines, penalties. That's kind of rare. But when you have a child with a lot of medical conditions and you want to be able to access that money, like they need to take a trip to the Mayo Clinic to see specialists and the parents don't, have a lot of money, that's an option you can consider.
Very good. Well, let's get to our viewer question. This one comes from Mitch in Decatur. He says, my kid was riding her bicycle on the street in the front of our house when a DoorDash driver hit her. She broke her arm and is in a cast for at least 8 weeks. DoorDash's insurance company says they aren't going to pay the medical bills because the DoorDash driver wasn't making a food delivery at the time. Can they do this? The DoorDash driver doesn't have any car insurance personally. According to that insurance company, which they say is Progressive, the driver let his policy lapse 2 weeks before my daughter was hurt. What can we do?
You want to tackle this one?
Yeah, it's a tough case, and we've seen this exact set of circumstances where, and it's true for DoorDash, but pretty much any kind of, third-party contractor delivery job. Could be Uber, could be, there are lots of different companies out there that do that. But the policy states that they do have liability coverage. It's just only available when the driver is engaged in an active pickup or delivery. They have to have active status within that app. And if it's outside of that time, then the liability coverage does not apply. And it sounds like that's what is being argued here. But it is a question of fact, and there are things that you can look at. You can look at driver's logs, and there's evidence that you could use to establish whether or not it was an active status, that the driver was in active status at the time of the collision. But if they were not, and that driver does not carry their own liability coverage through their own carrier, then we're talking about underinsured motorist coverage.
You have to lean on your own insurance coverage if there's no coverage with DoorDash or the driver personally.
Which goes back to what you guys have told us before. Make sure you have adequate insurance, because didn't you say 20%?
It's 19.5% of drivers in Alabama, not drivers, cars, like the actual cars out there that you see on the roadways don't have insurance on them.
That's a lot.
So almost 1 in 5.
That's a lot.
I mean, you got to protect yourself. You have to. I see a lot of terrible things where, I had to give a paralyzed guy a check for 25 grand once because that was literally the best we could do. There wasn't enough money to go get. Just because somebody runs a red light and terribly injures you, getting money from that person can sometimes be impossible. Anyways.
Our next email comes from Anna in Tuscumbia. She writes, I'm trying to negotiate a settlement for my child who was injured in a car accident when we were in together. The insurance company says that if the settlement is for more than $5,000, then they can't pay me the settlement amount directly, so they're only offering $4,500. Is it worth talking to a lawyer about this?
Yeah, I think so. I'm worried that the insurance company is using, so there is a statute, that states that a judge has discretion to distribute up to $5,000 to the parent for the care and well-being of the child. But what I'm afraid is being done here is they're using that as leverage to make the mom feel like we're not going to pay anything above $5,000. And so you need to call a lawyer, because the value of that case could greatly exceed $5,000. It doesn't matter, how much can be distributed to you. That's not the important question. The important question is, what's fair and adequate for your child's injuries. And so if it's more than $5,000, you're going to need someone like us to help go and get that, and then to handle the pro-AMI hearing that we talked about earlier.
If it's like got checked out at the ER and that's it, $4,500 may be fair. But if there's more to it, call a lawyer. Yeah.
And like you said, they are not billing you for anything until they recover something.
Yeah, we work on a contingency basis, which means we're only paid if we win out of the settlement.
And this doesn't happen very often, but you've had it happen, I've had it happen, where someone comes in to see us and they've got an offer from an insurance company that they're worried might not be fair. And most of the time, I agree that it's not, but occasionally we talk to someone and just let them know, hey, you don't need someone like us. In fact, this is probably something you can go and negotiate yourself, or that the offer they've made you, we think is fair. And so we're not always going to direct people towards hiring us if we don't think that's the best thing for them.
Yeah.
Okay. Well, thank you, Bart and Barnes. When the Siniard Law Show returns, we'll answer more viewer questions. Plus, we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
It's your news, your way, streaming now.
Every night, WAFF 48 is on your side, bringing you today's headlines.
Now to a story we've been following all afternoon.
Tonight's breaking news.
I'm on the scene of what is a rapidly developing situation here.
And tomorrow's first alert.
This is something we're going to have to watch over the next couple of hours.
Stream now, stream anytime, because your tomorrow starts tonight.
WAFF 48 News at 10. Your news on your schedule. Live and on demand on any device.
North Alabama's best attraction is not its mountains, or its rivers, or even its rockets. It's our people, honest, hardworking people who make us proud to do what we do. When people in our communities are injured in an accident,
we help them find insurance companies based in big cities far from here.
We are honored to help people get the compensation they deserve.
Siniard Law, nationally recognized, locally trusted.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code, or you can sign up at siniardlaw.com. Now let's get back to our topic tonight, personal injury claims when children are involved. Let's get straight to our email. This next email comes to us from Bailey. She says, my 2-year-old got hurt at daycare. She somehow got a second-degree burn on her arm. No one at the daycare will give me a straight answer as to what happened, but my kid keeps saying one of her teachers spilled something on her. I've called DHR and they're supposedly going to investigate, but I haven't heard anything back. Now the daycare just kicked us out of the daycare, and it seems like retaliation. What options do I have?
Well, she's got a claim. All you got to do to win a claim against a daycare is show that they did something negligent. And negligence is just the failure to use reasonable care. It was probably, I hope it was probably an accident. Okay, maybe, I've had a similar case where, a daycare worker accidentally spilled hot coffee on a kid, but even if it's just that, which I hope it's some accident like that, then your child's entitled to compensation for that. Second degree burns, that's painful, that hurts. Hopefully it heals up, but what if there's a permanent scar there, and them not giving answers is incredibly frustrating. I'm glad she's contacted DHR. That's the enforcement agency with oversight over daycares. Most daycares, there are exemptions. And DHR, for the most part, does a pretty good job investigating these things. ADPH investigating nursing homes, not so much, but DHR investigating daycares, they do a pretty decent job and are pretty thorough. They will try to find video surveillance footage. They will interview daycare workers who were involved and the director. So usually they're pretty good about at least getting some information out of the daycare. But I think it's a case where it's worth contacting a lawyer to see if a financial recovery can be made against the daycare's insurance. Most daycares, at least DHR regulated ones, are required to have general liability insurance when their workers do something negligent. It's a little bit trickier if this was an intentional burn. You would hate to think that, but we've seen cases of daycare abuse, not just daycare neglect. Sometimes teachers get frustrated and, do bad things in the heat of the moment. You still have a claim. It's a little bit different and more complicated. But I think it's worth contacting a lawyer.
Yeah.
Anything to add or?
No, just to do it quickly.
Yeah.
Don't wait for DHR to finish their investigation before you make a decision on whether to contact a lawyer.
Yeah.
It's probably important that someone like us goes ahead and writes an independent letter to the daycare asking them to preserve incident reports, surveillance footage, things that could become useful later on.
Yeah.
All right. So it's like what you said before, you're preserving the evidence so there doesn't suddenly get this answer of, oh, well, we erased or we ran out of memory space for our video, so we don't have it anymore.
We spend a good bit of time doing what we call preservation letters because no company out there, nobody in the world has any responsibility to preserve video footage. If I got a Ring doorbell camera that's showing something crazy going on, I'm free to delete it. That's my right as a homeowner. Business owners have the same right. I don't have that right to delete if somebody has sent me a letter demanding to preserve that video because it could be considered evidence in some type of legal proceeding. Once I receive that type of letter, I, as the Ring doorbell camera guy, have a responsibility to preserve that video. And if I don't, I could be found culpable, not criminally, but of what's called civil spoliation, where that person could actually sue me and say, you destroyed evidence, and get money damages against me. So in any case where we think video may be involved, a lot of car accidents, a daycare situation, premises liability where, there's a slip and fall at the grocery store, we know there's probably going to be video involved. We are sending out those preservation letters immediately. We're not waiting until, a couple of weeks down the road, because a lot of video systems overwrite. They automatically delete. It doesn't require any nefarious behavior. It'll just automatically delete. You got to get that letter. Sometimes I'll hand deliver it, just to make sure it gets there, because sometimes things get lost in the mail.
All right, very good. Our next question comes from Emma. She says, my son got some chemical spray in his eye. She says it was ant killer spray while I had a babysitter watching him. I'm pretty upset with the babysitter, but she's just a teenager and I don't want to take any type of action against her, but I took him to the ER and they gave him some type of sedative that ended up causing him to code. He has been in the pediatric intensive care unit for 3 days to recover and is now having breathing difficulties. What are my odds of winning a case against the hospital?
Yeah, that sounds like a pretty serious medical malpractice type case. Do you want to talk about that?
I respect the fact that she's upset with the babysitter, but doesn't want to go after the babysitter for that part. But it definitely sounds like the more critical claim here is the sedation claim. And you've probably got a medical malpractice claim against the anesthesiologist or the nurse
It's a hard one to say.
It is. We know what you're saying.
Yeah,
the person who gives the anesthesia.
Who administered it. And you would need to have an expert take a look at that, look at the drug that was used for sedation, and especially for children. Dosing is so important for children.
Critical.
And that's a common mistake because it involves mathematical calculations based on the child's age and their weight especially, to make sure that they're getting the appropriate amount of sedation. So it actually could even be a potential pharmacy claim. My wife's a pharmacist. She's going to kill me for saying that on air. But really, those are the different things that we're looking at. I'm glad that the child is okay because this is a case that could have ended much more badly.
Okay, but I signed all the papers. I took my kid to the ER and I signed all this stuff. Did I not sign away my rights?
You don't sign away your
my
rights.
Kids' rights.
You don't sign away your rights when you go to the hospital. But a lot of what those documents are that you sign that can relate to this is what's called informed consent. So, for example, you go in for a scheduled surgery, and one of the things they always have you sign is, usually nobody reads it. I don't read it, but I know what it says because I've seen them. But it'll say, you understand that a common complication of this surgery is the risk of infection, and that can occur no matter how sterile or clean the operating room is and the equipment used. You understand blood clots can form, no matter how perfectly we perform the surgery. That's not it exactly, but that's the gist of it. They list all these common complications that can occur in a procedure, and you sign saying you're aware of these and decide to undergo surgery anyways. So we see that, but that really wouldn't apply to this specific situation, because the child can't waive its rights. A child has no ability to enter into any type of written agreement in Alabama, so that doesn't matter. And B, this wasn't a common complication, or doesn't sound like it. We'd want to look at the dosaging. We'd want to look at what machine the hospital is using to dispense the medicine. Sometimes it can be a simple communication error. Sometimes it can be a dispensing error. Sometimes it can be an actual administration error where the nurse or the tech is actually administering too much and doesn't realize it until it's too late. Medication errors are scary. They happen a lot more often than you think, and they can happen in different ways. And sometimes it's a simple communication error that, in hindsight, it's like, wow, how did we miss that? But when you're caring for a lot of patients and things can be hectic, particularly in a pediatric ER, those mistakes happen. Doesn't excuse them though, particularly when something bad like this has happened and this kid's had to go to the ICU and is having lung issues.
Very good. Thank you so much, Bart and Barnes from Siniard Law, for answering these legal questions. And we look forward to hearing from you, our viewers, with questions about wrongful death, about pediatric personal injury, car accidents, nursing home issues, any legal topic. Just email us at questions@siniardlaw.com or call our voicemail at 844-7000-LAW. Join us next Sunday night after the late news.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.